We might still not know who came first, an egg or a hen. But you can definitely see the physical differences in both of them rhyming. Can't you? Likewise, there is a significant distinction between a shareholder and a director of a company in India. No, I'm not comparing them with a hen or egg, but the basic element in both of these cases is responsibility. The reason we are here right now is to discuss the fundamental distinctions between shareholders and directors of a company in India. So let's move and explain to you. In this video, you will see these categories: appointment and roles, powers and responsibilities, minimum members, liabilities of both, removal and remuneration of both shareholders and directors. First, let's grab a look at what shareholder or director is. Shareholder. A shareholder is part owner of the company to the extent of their shareholdings in the company. These are the set of persons that invest capital in the company, appoint the directors, and are entitled to the profits of the company in the form of dividends. On the other hand, a director is the top executive of the company responsible for its overall functioning and reports to the shareholder in their fiduciary capacity. They work in the best interest of the company and remain responsible for the general compliance of law as may be applicable to the company. Now let's talk about their appointment process. Shareholders. The company's initial shareholders are the subscribers of the Memorandum of Association, also known as MOA. Subsequent shareholders are added by the fresh issuance of equity shares and their subsequent allotment. Directors. The first directors are appointed by shareholders by nominating such directors in the AOA. The board of directors can add additional directors subject to the approval of the shareholders. Now let's talk about their roles. Shareholders. Being the beneficial owners of the company, the introduction of capital is the primary responsibility, and the secondary responsibility is to participate in the annual general meeting or the EGM for the decision making on the subject matters that are brought before the shareholders by the board of directors. And directors? The directors are top managers of the company who are responsible for the general functioning of the company with a view to increasing the shareholders' wealth. The directors have to ensure compliance with all laws that may be applicable to the company, including tax and corporate laws. Let's talk about their powers and responsibilities. Shareholders. The most crucial role of every shareholder is to invest in the capital of the company and to participate in meetings like the annual and extraordinary general meetings. This is because some of the most crucial actions of the company, such as changing AOA or MOAs and declaring dividends, the appointments of the director and the company auditors, requires the approval of shareholders and directors. Due to their involvement in the day-to-day operations and management of the business, their primary responsibility is to protect and act in the best interest of the company by making timely, effective business decisions and adhering to all applicable laws. Minimum members. Shareholders. In public companies, the minimum number is set at 7, whereas there is no maximum limit on the number of shareholders. In a private limited company, the minimum number is 2 and the maximum number of shareholders is capped at 200. With just one shareholder, a company can be formed as one-person company. Directors. The minimum number of directors in a public company is 3. In a private company, it is 2. While in the case of OPC, one-person company, there must be at least one director. The maximum number of directors in each of these 3 categories is 15. By way of adopting a special resolution in the shareholders meeting, the maximum number of directors may be more than 15. Now, liabilities of both shareholders. Despite being mostly protected by limited liability, they are nonetheless responsible for paying any outstanding debt when the company's board requests it, only to extend their unpaid part of the subscribed share capital of the company. And directors, liability occurs when he or she commits a fiduciary breach, acts outside the bounds of his duties as mentioned in the company's AOA, or acts negligently or with malicious intent. There are penal consequences for the directors for lapses or non-compliance with the laws. Now, removal. Shareholders. Being a beneficial right in the company, the shareholders cannot be terminated. However, under the provisions of the Companies Act, a shareholding can be transferred to another person. And directors? By a simple majority vote at an EGM, shareholders may remove a director. The Section 164 of the Companies Act contains the reasons for the disqualification of directors for certain reasons. Upon a director being disqualified, he ceases office of the director immediately. And the last part, their remuneration. Shareholders entitled to receive dividends when announced by the company, whether annual or interim, in accordance with company's AOA. And directors, they are entitled to sitting fees or any other remuneration received, subject to limitations set forth in Section 197 of the 2013 Companies Act. So, either you own a company or are you planning to incorporate one, this information will be very helpful for you in the whole process. If you found this video helpful and want to know more, you can check our website. Also, do subscribe to our channel, SetIndiaBiz, and let us help you get your dreams together. And check out our other videos as well.